law enforcement, including Taos County Sheriff and the FBI. Now, the issue is that we are in receipt of almost no what would be characterized as lapel videos from this investigation. We are also not in receipt of, and has not been provided, is a tape-recorded interview with one or more of the children that was conducted by FBI personnel. Actually, the witness that is subpoenaed here today. And so the rule is very clear that those items were required to be provided, and we really do not have a fair opportunity under Rule 409 to cross-examine these witnesses without these disclosures that surely exist and surely are in the possession of the state. So that is one issue that we need to take up, and I think that Mr. Clark has a related issue.
Mr. Clark?
Your Honor, on behalf of my client, I'd like to address what's just been handed to me, identified as States 38. Several handwritten pages from, it looks like a notebook. I can only assume the states had this in their possession based on some news reporting, and to dump this on me and my co-counsel at this 11th hour flies in the face of due process. I suspect what the state is going to do is rely on this through our dangerousness of all the defendants and require their continued detention. To dump this on me before a trial starts with this magnitude, with this much media coverage, I think it's somewhat shocking. Now, the handwritten pages beg the question: where did this come from? Whose handwriting is this? What's this all about? Is this a teaching manual or recitations from a teaching manual, or is it in fact teaching material? I don't know. There's no reference in any of this except handwritten pages. And so there's no way to know where this came from, and it's awfully easy to take things out of context when you're making allegations of this sort. And so I have some huge problems. Number one, with the admissibility of this document, which is States 38. But the bigger question comes, or the bigger question that's raised is, how long have they had this, and why was this turned over in the mountain of discovery that I have received? There's no reason it should not have been turned over right away with everything else.
All right, Mr. Hassan, do you want to respond to that?
Yes, sir. Your Honor, this is an extraordinary case with, as the court will see, some extraordinary facts. The district attorney's office first became involved in the ongoing procedures leading to this hearing on Thursday, August 2nd, when we reviewed the first set of search warrants. Since that time, we've been working ceaselessly to process the events that have taken place and the evidence that has been produced. We have made every effort to be as fair as possible and convey the evidence to all the attorneys as soon as we possibly could. As the court probably knows, only one of these 5 defendants actually had counsel that they knew of, which was Mr. Kostic, until the public defender's office was able to arrange for attorneys from other places to represent them. And so therefore, I think most of them were unable to get the greater part of the evidence disclosed to them on thumb drive until this morning. But we had it available to them on Friday. As for Mr.
You're referring to the lapel videos and the tape-recorded interviews?
That's correct, right? With the exception of the FBI interviews that Mr. Kostic mentioned.
Okay. So the lapel videos, but not the interviews with the FBI and one or more of the children?
To my knowledge, those lapel videos have been disclosed. Let me put it this way, and that's because that's where I'm going in the rule, but everything that the district attorney's office has received by way of videos and photographs, etc., I believe has been disclosed on the thumb drives. I haven't looked at them myself, but that is my understanding. But the discovery aspect of Rule 5409, to to correct Mr. Kostic actually requires that language was carefully used by the Supreme Court in issuing this rule. There's a lot of evidence in this case, Your Honor. It's being processed as fast as we can do it, but it's possible that some of that simply can't be made available on the short timeline that the Supreme Court has imposed for these hearings under Rule 5, 4, and 9. So we've made every effort to be as fair and to disclose everything we possibly can. It is pursuant to that effort to be as fair as possible, Your Honor, that we just passed out Exhibit 38, which was handed to me approximately 25 minutes ago. And that's because I guess it was just processed by those who are continuing to process the evidence, to catalog it and photograph it. This Exhibit 38 refers to a notebook apparently that was taken into evidence and was just this morning photographed, because that's when the officers are getting to it. So even though I haven't read it, in an attempt to be really fair to the defense, we've distributed it to them.
And if I could respond briefly, Your Honor. The problem here is this. One is that we're receiving, it looks like, voluminous discovery via disk here as we enter the courtroom today. I have personally reviewed that thumb drive that was distributed on Friday, as has my investigator. Neither of us see that there is anything other than what are characterized as 2 safe room interviews with children and 1 2-minute video that was from Sheriff Hogarth. There are absolutely, and I know that there were many personnel involved in this investigation to this point. No lapel videos from them. Also, no interview from the FBI.
All right, well, Mr. Kostic, you do know that these are very expedited proceedings, and so what would your remedy be? What would you propose as a remedy for these supposed violations that you're
and you know, I think that that's got to enter into the calculus of the state when they decide which cases they're going to file for pretrial detention. Now, if they are not in a position to give to the defendants fairness, to give them due process, to give them, to make that rule effective, then maybe they should think of another plan. They not only had, they had essentially 3 days previous to this motion being filed in which to work on these disclosures and this evidence. They delayed filing, as you remember, Judge, they dismissed this matter after it had been pending in the magistrate court for 3 days, then refiled in the district court along with this motion for pretrial detention. So they have had plenty of lead time in order to give us the disclosures so that we have a fair opportunity to cross-examine these witnesses, not right as we're walking in for a hearing.
All right, thank you, Mr. Kostic. Yes, Mr. Clark.
Your Honor, my concern is much more practical. And I, upon information to believe, at least the Sheriff's Department's had this document for since the very beginning.
Well, I don't know that. Yeah, I don't know if Mr. Hassan knows that. Mr. Hassan, you said you received that today, just as you came in the courtroom or something, or?
Downstairs, just before coming up here.
And where was it received? How was it received?
It was taken as part of the evidence seized pursuant to the August 6th search warrant, I believe. August 6th.
Search warrant, oh, okay, so that's 7 days ago. And in whose custody was it in?
It was initially in the sheriff's custody, and I believe that the sheriff is being assisted by, I can ask the sheriff this when he testifies. I believe the Department of Homeland Security is assisting the sheriff's office in the cataloging of evidence. But as I said, there are a lot of items there. There have been search warrants executed since the August 6th search warrant. And of course, in that period of time, there are also 11 children that were taken into CYFD custody. and have been interviewed for their safety, as is customary, but also out of those interviews has come some evidence that we used in these cases by the state. But of course, we learn about it, Your Honor, as this evidence develops, and it's simply continuing to develop in an unusual way. So, the facts, Your Honor, and the evidence are frankly shocking and alarming, but I don't think the state realistically is faced with the choice in some situations of, well, we'll wait until we have all the evidence organized. The Rule 549 is intended to reflect the new constitutional amendment, which is about safety of the community and safety of individuals in the community. And so that's why it's expedited. So I think the state has a duty where it sees the need to ask the court for pretrial detention. And of course, if the defendants discover new evidence later, they can ask to revisit the question.
Thank you. So I'm not sure what remedy was being sought, but at this time I'm going to let the hearing is going to go forward. And I think under the rule, if something is proffered during the course of the hearing that you believe is improper, of course it is your right and duty to object, and my duty to determine whether or not that objection is going to be sustained. But and you do have the right, if there was a pretrial detention order entered today, to bring that up again at some later date. So, having said that, Mr. Hassan, are you ready to call your first witness, or do you want to make an opening statement?
Here's how the state would like to proceed, Your Honor. First, Mr. Lovelace is going to make an opening statement to the court. The evidence is kind of unusually complicated for this kind of a hearing. Made a proffer. There are a number of documents which are bound and which have been distributed both to the court and to counsel for each of the defendants. So after the opening statement, I want to outline those documents, discuss those documents with the court, and then having done that, the state wants to call 3 witnesses, and then that will be the sum of our presentation. So Mr. Lovelace will make an opening statement.
Your Honor, another brief matter before we begin. I mean, what I'll ask for is you raised the issue of remedies. What I would ask for is actually for the testimony of Special Agent Taylor to be suppressed today, because we do not have, again, a fair opportunity to confront him, cross-examine him without a recording, without the ability to review the recording that he did of this interview with one of the children in the case. And so, I mean, that would be where the thrust, I would imagine, of his testimony would come from today. And so I don't think it's necessarily fair for him to be able to testify and us not have an effective opportunity to cross-examine.
I'm going to deny that, because I don't believe that the purpose of this hearing is to determine whether there are any conditions that could protect the safety of the community, any conditions of release. That is the purpose of this hearing. It is not a determination of guilt or innocence. It's not a determination. And these are expedited proceedings. It's difficult to get everything together. I understand your concern about it, Mr. Kosich, I really do, but we're gonna go forward now. And so, Mr. Lovelace, will you go ahead and make your opening statement?
Well, one other thing, Your Honor, I guess before Mr. Lovelace began, I would ask for the rule to be invoked, and also for potential witnesses not to be instructed not to discuss testimony.
The state's witnesses will please leave the courtroom at this time, and you're instructed not to discuss your testimony among yourselves while you're outside waiting. You may proceed, Mr. Lovelace.
Thank you, Judge. As Mr. Hassan stated, this is an unconventional hearing. This will be an unconventional opening statement. And I will ask the court's patience on a few things that become more relevant. As far going to begin in 2015, in which one of the defendants, Siraj Wahhaj, was a resident in Atlanta. He took firearm classes in rapid succession. In January 2015, he enrolled and completed a basic pistol class, immediately followed by a defensive pistol class, completed in March 2015, followed by an AR-15 class, completed in April 2015. Staff at the Atlanta Firearms Training Center stated they had never seen someone take these many classes so quickly in rapid succession. Further, in October of 2017, Mr. Siraj Wahhaj traveled to Saudi Arabia. Now, this point will become relevant very soon when we get to the context of his family's concerns for his son, Abdul-Ghani. December 3rd, 2017, Siraj Wahhaj is believed to have left Atlanta with his son, Abdul-Ghani. His wife, Hakima Ramzi, spoke to police and stated that Mr. Siraj had taken their son to a local park and he had never returned from that trip. Hakima and his stepmother, Jamila Jihad, later spoke to police on December 14th and stated that Abdul-Ghani was prescribed 2 separate medications for a condition he had that affected his health. Jamila Jihad expressed concerns to the police about Mr. Siraj since he returned from a recent overseas trip. Since that trip, Mr. Siraj had stated that he wished to halt all medication for his son, Abdul-Ghani, and he wished to have religious rituals performed upon Abdul-Ghani to cast out demonic spirits from his body. He had also texted his wife, Hakima, that he wished to have a divorce. December 13th, 2017, there was a similar rollover crash in Chilton County, Alabama. There were 9 individuals involved in this crash, 7 children, 2 adults.
What day was that?
That was December 13th, 2017. One of the adults was Siraj Wahhaj, the other Jamie LaVille. Siraj Wahhaj told the officer that the group was traveling to New Mexico for a camping trip. Among the items found in the rollover vehicle were a 9mm Kimber and a holster on the hip of Mr. Siraj, a Glock 380, and a Smith & Wesson 38 Special. A bulletproof vest was also found, and a vest with magazine pouches and magazines in them, several in the AR style, were found in the vehicle, as was a bag containing ammunition. Mr. Siraj claimed he was married to Jenny LaVille. However, later LaVille stated that she and Siraj were not legally married. Mr. Siraj Wahhaj disclosed that he worked as an executive security business. After this rollover, Lucas Morton arrived on scene with a budget rental box truck. Mr. Siraj and Mr. Morton took the property from the rollover crash, transported it into Mr. Morton's big box rental truck, including the guns. They did not open the back of the truck. They transported the guns through a cutout in the cab, which allowed access to the back of the vehicle and prevented the officer on scene from seeing what was inside the back of the vehicle. On December 28th, Georgia police began a search for Lucas Morton in an attempt to find Siraj Wahhaj and Abdul-Ghani. Investigators found Morton had recently changed his mailing address to a UPS store in Taos, New Mexico. On December 31st, 2017, the Clayton County Police in Georgia found out that Mr. Morton was back in town. Mr. Morton told authorities he did not know where Siraj Wahhaj was at, only a few days after helping Mr. Siraj Wahhaj move items out of his vehicle in Alabama. Mr. Morton had given Muhammad, the brother of Siraj Wahhaj, a letter. The author of this letter is suspected of being either Siraj Wahhaj or Jenny LaVille. The letter in part reads, "Allah says He will protect you always, so follow until He makes you die as a martyr, as you wanted. And the only way is by joining the righteous, parentheses, quote, parentheses, us, unquote." The letter instructs Muhammad to hurry, not to drag his feet, to, quote, "leave whatever we told you to leave. Take all your money out of the bank and bring your guns," unquote. The letter also commands Muhammad not to speak to his father and, quote, don't put us in danger. According to some of the interviews conducted on the children, religious rituals had been performed upon Abdul-Ghani while the group was in New Mexico. According to these interviews, Jenny Lavelle was one of the leaders in conducting these rituals. Some of the children have stated that these rituals were intended to cast out demonic spirits from Abdul-Ghani's body. All 5 defendants knew about these rituals, and among the items located at the compound was a book titled Sword Against Black Magic and Evil Magicians. According to some of the interviews from the children, around approximately February of 2018, Abdul-Ghani died during one of these religious rituals. His body was washed multiple times, wrapped in sheets. The body was eventually moved to one of the sections inside the tunnel. Everyone at the compound prayed to Abdul's body, and the children were told that Abdul would be resurrected and come back as Jesus. According to some of these interviews, upon Abdul-Ghani's resurrection, he would instruct the group on what corrupt institutions the group needed to get rid of. These institutions included teachers, military, law enforcement, financial institutions. According to some of these children's interviews, some of the children were instructed on how to operate firearms, as well as room clearing techniques, tactical reloads, disarmament techniques, in case the FBI, CSI, or police ever came to the compound. Of note, a shooting range was found on the compound, and there were markers on the range denoting the numbers 50, 30, and 15. These may have been distance markers to denote the range for firing drills. In May of 2018, a neighbor complained to the Sheriff's Department the Wahhaj group at the compound were firing their assault rifles so frequently that he had to ask the group to stop due to becoming a nuisance. Among some of the items found in the compound was a book titled On Combat, the Psychology and Physiology of Deadly Conflict in War and Peace. An Amazon.com synopsis of that book includes mention that the book discusses new research on what warriors can do to limit the effect and stress of deadly battle have upon the nervous system, heart, breathing, visual, auditory perception, and memory. Also among the items found was a document titled Untraceable Assault Rifle, Build Your Own Untraceable AR-15 at Home. Around July 31st, 2018, Subhana Wahhaj, one of the defendants, asked a family friend to send the group food and money and to not tell anyone. She did not state that there were any problems. She did not request to be rescued or wish to leave.
Which one was that?
That was Subhana. On August 3rd, 2018, the Taos County Sheriff's Office executed a search warrant on the facility. Lucas Morton was encountered near his truck. Within the truck, a shotgun and handgun were found, as well as a bulletproof vest. Siraj Wahhaj was found in a travel camper further within the compound. He was in possession of an AR-15 and handguns. Siraj had a belt with 5 pouches. Those pouches contained loaded AR-15 magazines, 30 rounds of ammunition per magazine. Near Siraj were at least some of the 11 children. Some of these children were handling ammunition at the time. One of these children stated in one of the interviews, at the time police arrived, one of the other children was armed with some kind of firearm. Additionally, more firearms were found within the 100-foot-long tunnel underneath the main compound. Rifles with scopes were found in carrying cases near the exit of the tunnel. These rifles were 308 and 30-30. Also found in its purchase case was a Glock 380. These were all found near the exit to the tunnel. A backpack full of ammunition was also found near this exit. The state anticipates calling Sheriff Holgrove, who will testify regarding the search of the compound, the weapons seized, as well as the tunnel, weapons within the tunnel, and a body found within the tunnel. Under Sheriff Steve Miera will provide testimony regarding the layout of the compound, how its structure and materials used around the compound would assist the inhabitants with any confrontations with outside intruders, such as law enforcement. It's anticipated that FBI agent Travis Taylor will testify to his interviews with some of the children and the contents of those interviews. At the conclusion of the state's presentation of evidence, exhibits, testimony heard, the Say we request that this court find that no lesser means can secure the safety of this community other than holding these 5 defendants in custody without bond pending trial. Thank you.
Thank you, Mr. Lovelace.
Your Honor,
Mr. Clark, did you want to make an opening statement?
no, I'd waive opening at this
All
time.
right, anybody wish to make an opening statement on behalf of their clients?
No, thank you.
No, Your Honor.
No, Your Honor.
Thank you,
No,
President.
Your Honor.
All right, Mr. Hassan, you may proceed.
Thank you, Your Honor. Your Honor, in the case of State v. Groves, which was published in January of this year, Justice Daniels set out very clearly the 3-step process that the courts must follow in these kinds of hearings. The first step is to determine which information in any form carries sufficient indicia of reliability to be worthy of consideration. The second step is to determine the extent to which the information would indicate a threat to others if the defendant or defendants are released. And the third step then is to determine whether any potential pretrial release conditions would reasonably protect the safety of others against those potential threats. So pursuant to that first step outlined in Graves, I wanted to review the proffered documents with the court so that you have an understanding of where they come from and what their relevant reliability is. And I hope we've made it a little bit easier for the court given the volume of evidence. Exhibit 1 is the actual index to the exhibits. And Exhibit 2 is just a partial summary of the facts that the state is proffering to the court. It's not a pleading, it's intended as a demonstrative aid, really, so it may not be exhaustive, and it's not in the sense that witnesses will testify. But I've tried to list the salient facts there for the court with references after each one to exhibit numbers that relate to those facts. So, just going through the proffered documents then, Your Honor. Exhibit 3 is a document produced by the FBI office in Albuquerque. It's dated May 15th of this year, and it appears to summarize some information that the FBI has gleaned over time on Siraj Wahhaj, defendant here today. And it is this document that provides the information Mr. Lovelace mentioned to the court in opening about the firearms training Mr. Ibn Wahhaj obtained in Georgia in 2015. It notes the comments from the company that provided the training in their tip to the FBI that they've been open for 5 years and no one has taken that many classes this quickly in that period of time. So that is what made them suspicious. This document, just adding to the reliability of other evidence presented to the court, also notes the December 15, 2017 crash in Alabama that Mr. Lovelace told you about on I-65. It contains some of the troopers' comments, although this Alabama State Troopers report is also one of the proffered documents, Judge, so you can see how these relate and interlock, so to speak, in terms of reliability. It also notes the comments made to the Clay County Police Department in Georgia by Mr. Wahhaj's wife in the Atlanta area, that ever since his overseas trip, September, she said, in 2017, he talked about conducting exorcism to heal the child Abdul-Ghani and to deprive the child of his necessary medication. So that's Exhibit 3. Your Honor, Exhibit 4 is an excerpt from an incident report of Clayton County Police Department Officer Griffin, which documents the defendant Ibn Wahhaj's statement, the statement from his wife that he had contacted her and that he texted her saying a divorce. He wanted a divorce. It's relevant, Your Honor, because it marks the defendant's attempts essentially to cut ties, it looks like, in the Atlanta area as he relocated to New Mexico. Exhibit 5 is an excerpt from another report, sort of a supplemental report related to Exhibit 4, and documents Officer Beach from the same police department noting that he had contacted the defendant's wife, Siraj Wahhaj's wife, Hakima Ramzi, and that she noted that the child was still missing, that she hadn't seen him since her husband took the child at the end of November, and that he's not answering or returning phone calls. It also documents her information that the child was disabled and the child needed medication in order to avoid seizures. Exhibit 6, Your Honor, is a 3-page exhibit which is part of the accident report filed by Alabama State Trooper Earnhardt, and it documents the facts Mr. Lovelace mentioned in opening, that on December the 13th, it was about 2 in the morning, there was a single vehicle rollover crash on I-65 in Alabama. This Trooper Earnhardt responded to the scene. He identified the driver as Siraj Ibn Wahhaj. He identifies him by date of birth and name, and taken from his driver's license. He noted that the defendant told him they were traveling from Georgia to New Mexico to go camping. The officer thought it suspicious because he didn't see any camping equipment in the vehicle or outside the vehicle. The vehicle was overturned. He said Mr. Wahhaj told him that they had just moved to Tuskegee, Alabama. He said he works for a company that does executive security. He named that company, gave him an internet address. The officer tried to look those things up and found no information on the company and no valid internet site at that address. The officer then spoke to defendant Jenny LaVille, who's here today, whom Mr. Wahhaj had named as his wife. She told the officer they were not married. She told him they were going to New Mexico just to see Mr. Wahhaj's brother-in-law owned some land there. They wanted to go see the land. It documents the recovery of weapons, Your Honor, which ultimately were recovered in New Mexico at the execution of these warrants. So the rifles and the handguns that were in Mr. Wahhaj's possession in that Alabama wreck were later recovered in New Mexico. That's Exhibit 6. Your Honor, Exhibit 7 documents the issuance of a pickup order by the Juvenile Court of Clayton County, Georgia, on December 18th, 2017, finding probable cause that the child, Abdul-Ghani, is in danger and ordering that he be picked up by law enforcement if he was encountered. Your Honor, Exhibit 8, and I haven't been commenting, but some of these documents, the questions about reliability at this point of these documents, Your Honor. One is by the FBI. 3 are police reports. Just noting that in the discussion of the case law about reliability, one of the things Justice Daniels pointed out is that even unsworn police reports may have substantial indicia of reliability in the discretion of the court, and they are an acceptable and likely form of proffer from the state in these kinds of cases. Exhibit H, Your Honor, is part of an investigative timeline. This was prepared by Captain Stubbs of the Clay County Police Department, documenting his investigative efforts since last December. And I'm seeing a typo at the top, 12/28/19. Captain Stubbs and Officer Porter in Clay County have been conducting an ongoing investigation. The earlier documents are reports from the same department, trying to locate the child since he was been reported missing. It's this document